Good afternoon, my Real News Midday TV family. Welcome back to the channel for another news update for February 5, 2024. Please remember to leave a comment, like, and share. And in the news this afternoon, no further progress in Daniel Rowe's murder case. An incomplete case file has resulted in the matter against the Coyote Sechelle, the dental assistant who is charged with the abduction and the murder of 80-year-old Daniel Rowe, being pushed back to March 14. Prosecutors on Thursday told a High Court judge in the Home Circuit Court in downtown Kingston that while the case file is incomplete, it is nearing a stage of readiness. At the next court date, the prosecution said it intends to make some documents available to Sechelle's defense team. The accused woman was further remanded as a result of the developments. Sechelle is said to have been identified as the woman who allegedly abducted Daniel Rowe from her school in Portmore, St. Catherine on June 8, 2023, before the child's throat was slashed in the corporate area the same day, resulting in her death in hospital 2 days later. The police said Sechelle was an intimate partner of the now deceased child's father, who is a serving member of the Jamaica Constabulary Force. The accused woman was picked up in the corporate area on Friday, August 11, 2023, giving the police a breakthrough with their extensive probe of the grisly murder of the child. In October of last year, Sechelle was denied bail over concerns about her safety in light of public outrage relative to the schoolgirl's brutal murder. DPP and the judge at odds after case withdrawn before sentence that would shock public's conscience. There is a legal firestorm brewing over the Director of Public Prosecution's withdrawal of a case last month from a judge who was about to sentence a man who had pleaded guilty to rape and grievous sexual assault. DPP Paula Llewellyn has been chastised by the judge and criticized by several members of the legal profession for her action. They have emphasized that the DPP had the right to appeal rather than to stop the proceedings and start afresh before another judge. It was reported that the judge, who was visibly upset, remarked that the DPP had also stopped a murder case some time ago in which the judge was to preside. But in response, Llewellyn said what she did last month in entering a nolle prosequi was done in the interest of justice, because a non-custodial sentence that was being indicated was not the appropriate sentence given the gravity of the allegations. It cannot be that the pendulum of justice must only swing in one direction for the accused. It must also swing for the victim, Llewellyn stressed. She said the process in arriving at the sentence was irregular. Attorney at law George Clue, president of the Southern Bar Association, when asked for a comment on the issue, said last week that he heard about the matter from some attorneys who were present in court on January 26. In my view, it is an abuse of discretion to use nolle prosequi in that manner, because if the DPP is dissatisfied with the sentence imposed by the judge, she can appeal it, Clue asserted. He said that the case would now have to go before another judge. If a sentence is too lenient or a judge imposes a sentence that he or she is not empowered in law to do, then the DPP can appeal, Clue added. On December 18 last year, when the social inquiry report was ready, the judge again indicated the sentence that was going to be given in accordance with the sentence indication, and it was reported that the judge then remarked that it was open to the Crown to appeal if it was aggrieved by the sentence. Senior attorney at law Leonard Green, who is president of the Advocates Association of Jamaica, explained that the court's power to give an advanced sentencing indication comes by way of Practice Direction No. 2 of 2016. This is an essential tool that allows the accused an opportunity to know in advance what would be the likely sentence that he or she would face if a plea of guilty was entered. It has a tremendous value and remains a helpful procedure that the judges use from time to time to reduce the backlog of cases before the court. It is vital that the accused persons and the lawyers have confidence in this procedure so that if they decide to use it, that there is a real likelihood that they would receive some advantage for not wasting the court's time if they know that they are guilty for the offense for which they have been charged. If the office of the DPP adopts the view that they are entitled periodically to have the process aborted by entering a nolle prosequi and start the case afresh, then there is a real likelihood that persons charged may be less inclined to use this process as a means of disposing of their matter rather than going the route of a full-scale trial, Green said. So it is not right to say that in all cases you are going to wait until appeal before the damage would have been done. The allegations revealed an awful sexual assault which was perpetrated on the victim, Llewellyn, however, said. She pointed out that the information from Senior Deputy Director of Public Prosecutions, Jeremy Taylor Casey, who first had the conduct of the matter, was that when the matter was first discussed in October last year in respect of sentence indication, Taylor said he would not agree to a non-custodial sentence given the gravity of the allegations. We believe that such a sentence would shock the public's conscience, she added. The judge apparently did not seem to be in disagreement with what the defense counsel was saying, Llewellyn said. One understands the urgency which all stakeholders share to dispose of matters. However, because we are dealing with real people who have been assaulted or victimized or killed, prosecutors have to explain to the victims or their relatives how come the judge is going outside of the sentencing range, she disclosed. Taylor, in outlining what took place, said the trial was going to start, so the complainant was at court. He said he and another colleague had the conduct of the prosecution. However, before the accused, the man who was charged with rape and grievous sexual assault was pleaded, in October last year, his counsel asked if he could approach the bench. He went there, and what I would describe as an informal sentence indication took place. I said informal because it did not conform to the practice direction and it did not conform to the structures laid down in the case of the King and Adrian Brown, which should have been done in chambers with a writer and normally to get a social inquiry report, and that was not done, Taylor said. This was done in the bar of the court. When the judge said in the bar of the court, I am minded to give him a non-custodial sentence, the Crown said no because on the facts of this case, the offenses were egregious and we could never agree to a non-custodial sentence. This is a case where the accused lured the girl by way of social media to where he lived, and without her consent, he held her down and raped her and held her down so that his friend could rape her too. When we went back to counsel's bench, defense counsel asked for the accused to be pleaded, and he pleaded guilty, and a date was set for sentencing. On the date for sentencing, I was present, and I put forward sentencing submissions as to why in this case, a non-custodial sentence must not be given. I even cited authorities to show that notwithstanding the age of the accused at the time of the offense, a non-custodial sentence was not appropriate, Taylor outlined. The matter was set for another date. On December 18, 2023, when the case came back before the court, Taylor said he was not there, but from reports from the prosecutors who were in court, the social inquiry report was ready, and the judge indicated to the prosecution and the defense counsel that she was going ahead with the original sentence, so when it came to his attention, he approached the DPP. We even consulted with the complainant before we consulted with the DPP for the nolle prosequi, and the complainant was shocked that the judge was minded to give a non-custodial sentence. The nolle prosequi was entered on January 26 for the matter to commence before another judge, Taylor said. It was reported that the accused at the time of the incident was 16 years old and the complainant was 17 years old. Llewellyn explained that the other case the judge referred to was the murder case of 3 policemen, in which the judge became upset and was pressuring the prosecutors not to use their challenges in the empaneling of a jury because there was insufficiency of jurors. The judge did not give the same instructions to the defense, she said. When prosecutors contacted me, I told them they were on the ground and that they were to exercise their independent judgment on behalf of the prosecution, she said. She commented further that it was the perception of the prosecutors that to meet the justice of the situation and to give the prosecution the best chance in the case, they had to challenge the jurors. A jury was not impaneled that day, and the case was set for another date. The DPP entered a nolle prosequi and directed that the case be set for a trial before another judge at the next session of the circuit court. As officers of the court, we always pay great respect to the judiciary and the fairness requirement to due process for the accused. However, we are obliged to maintain an independent professional judgment from all stakeholders in the administration of justice while we balance all factors with the public interest, Llewellyn said. A retired judge said in relation to sentence indication, both parties must agree to the sentence. The eminent jurist advised that once the prosecution objects to the sentence indicated by the judge, then the matter must go to trial, and in this particular case before another judge.